Foster is here on behalf of the state. Good afternoon. Mr. M, are you ready to go?
Sure.
Is that how you pronounce your name?
Yeah.
M.
Yeah.
We're on the record and calling the case of State of Washington versus Joshua M. President on behalf of the state deputy prosecuting attorney Marcus Foster.
How you doing?
Mr. M is representing himself pro se. And I will advise the party that I have read the document filed by the defendant, Mr. M, entitled Notice to Court, Memorandum of Laws, Judicial Cognizance. And I've read the state's response to the defendant's motion to dismiss. And so I believe it's your motion, Mr. M?
Yes. The motion to dismiss.
Speak loudly and give me your argument.
Um.
And when you address the court, you'll need to be standing.
Oh, that's right. Well, I actually I had a response to his response because I just got it yesterday afternoon, and I kind of wrote it down. Would it be good to read it to you? Or, I mean, I stand on my motion to dismiss as it is, based upon the facts of the case and the circumstances thereof, being that my understanding of law is that the government was created to protect and maintain individual rights, whereas there are no rights allegedly violated in this case. It's the allegations are the violation of a statute and a code. So my biggest question is what facts are in evidence to prove that the statutes and codes apply to me because of my physical occasion? And the claimant for the state, the prosecutor for the state says, well, because you're in the state, the laws of the state apply to you. But what facts are in evidence that I'm in the state? Can I be in the body politic? Is that even possible? Can I be in the plaintiff? These are highly illogical and improbable to even prove to be in the plaintiff. Typically a plaintiff is one who is an artificial or a natural person who brings an action in his own name. And then you go back to what government was established for, and that's to protect and maintain individual rights, not enforce statutes and codes as far as I understand. So I haven't seen any facts to prove that those statutes and codes apply to me specifically. And then I also, as you've seen in the memorandum of law that I gave you, let's see, it would be...
I have this working copy of this entire packet here.
Yes, and you went over that?
I read what I said at the beginning of this case, that I reviewed both parties' pleadings.
Notice of Court Memorandum of Laws and Judicial Cognizance. I go about how I was pulled over for a mere traffic infraction. And the case law and the rules of law is that when those lights are on, you're under arrest as soon as those lights are on. And case law also has it that any restraint on liberty, no matter how slight, is an arrest. Unless it's done unlawfully, then it's a kidnapping, right? So logically, if a traffic infraction is not a crime, it's not an arrestable offense, but I was arrested for it as soon as those lights were on, then I should have been Mirandized immediately. But there was no Mirandize in this whole case. I was not given Miranda warning before any of the investigation began. And then you continue on, and I contacted the Department of Licensing asking them where this personal driver's license is in the law, and it's not even established in the codes. The only valid licenses are Class A, Class B, Class C, and they're claiming that my personal driver's license is suspended. So I asked them, where is the personal driver's license defined in the law? They said it's not. So that looks like fraud to me.
Looks like what, fraud?
It looks like fraud. They're issuing licenses that don't exist.
How is it fraud?
Is it not a fraud to give somebody something that doesn't exist?
One thing, Mr. M, I ask you the questions, you don't ask me the questions.
Okay.
You tell me, how is it fraud?
I would say it would be fraud because I was sold something that I was not made aware of, did not exist in the law, whereas I should have received a Class C. Likewise, we also have found in case law and the statutes that the driver's license is in fact not required unless you're involved in commerce. And I've never been involved in commerce on the roads. So there's a whole slew of things. There's no violation of a right, no cause, no harm, and no facts to prove that the Constitution and the laws apply to me specifically because of my physical location, absent the fact that some people would use physical force to make me comply. Otherwise, I believe that I should be free to do as I please so long as it hurts no one else and damages no one's property.
Did you, in your memorandum or the materials you filed with the court, Mr. M., did you cite any specific case that's factually similar to yours?
What do you mean?
Dismissed based on the same grounds that you're asking the court to dismiss.
My girlfriend actually used the same motion to dismiss in Ritzville here in Washington State, and they dismissed within days after receiving the motion to dismiss that I submitted here. But there's been more others. I would have to do some research and find them.
Right.
There are more other cases that have used the same motion to dismiss style and in this state, and they have been dismissed and even won on appeal. But I would have to go and do research, and it wouldn't take me very long, just a couple days. I know the people, so I'd have to find it.
Is there anything further you want to add?
I would like to give a response to the prosecutor's response. So I object to the prosecutor's response to my motion for being vague, non-responsive, and untimely as it was submitted yesterday morning as an appealable issue of sustained. Prosecutor's response implies that I have made claims that I have appeared generally before the court to dispute the charge and that the RCWs apply to me because the RCWs say they apply to me. Point one is I have made no claims of my own, only those that the Constitution and Supreme Court have raised. And that is that there must be an alleged rights violation causing loss or harm to the plaintiff specifically. The foundation of the court's jurisdiction is the purpose of government itself. All political power is inherent in the people, and governments derive their just powers from the consent of the governed and are established to protect and maintain individual rights. That's Washington Constitution, Article 1, Section 1. And this is why to have a case or cause of action, a plaintiff, in this case, state of Washington, must plead the violation of its own legal right. And the duty of this court, as of every judicial tribunal, is limited to determining rights of persons or of property which are actually controverted in the particular case before it. That's Tyler versus Judges of the Court of Registration. The basic elements of a cause of action is the violation of a legal right and loss or harm. The alleged plaintiff, state of Washington.
Filed, or is this just an argument?
This is my response to his response.
Have you filed it?
I'm going to file it right now.
Have you given him a copy?
Yeah, sure. There you go. I have one for the court as well.
Sure, you can hand that out. So the record should reflect that Mr. M has filed a response to the state's response or a reply to the state's response.
Yes. It's a response to the state's response to my motion.
Response to the state's response to the motion to dismiss.
Can I finish reading it?
Reading from the document beginning on what page?
Page 2, about the middle of the page, after the first Supreme Court ruling, Tyler versus Judges of the Court of Registration. Would you like me to continue?
If you want to read it, go ahead.
Okay, so the basic elements of a case or cause of action is the violation of legal right and loss or harm. The alleged plaintiff, State of Washington, a legal fiction at best, ostensibly acting through the cop or prosecutor, has not pled a violation of a legal right or harm. The allegation is of a violation of a statute. Legally, there is no cause of action. A cause of action is some particular legal right of plaintiff against the defendant, together with some definite violation thereof, which occasions loss or damages. That's Lucky versus McCall Manufacturing Company, and Sewall versus Martin. This includes proceedings like these allegedly criminal in nature. Causation consists of two distinct sub-elements. As legal scholars have recognized, before a defendant can be convicted of a crime that includes an element of causation, the state must prove beyond a reasonable doubt the defendant's conduct was, one, the cause in fact, and two, the legal cause or proximate cause of the relevant harm.
Let me ask you a question, Graham. Aren't you reversing civil causation into a criminal case?
Say it again.
What you're reading, what you're citing is causation, proximate causation, which is really not an element of a criminal case or criminal proceeding.
Okay.
So
what makes
I'm not
this?
sure how that fits.
As far as I understand, every crime must have a victim. So who's the victim in this case? That's my question. Like, is there a victim here? Nobody has a claim against me?
The allegation is that you were driving without a license while you were suspended.
Mm-hmm.
And the allegation is, and the court has found that you were stopped, and there was probable cause for the stop based on a violation of an infraction.
Probable cause for the stop is a taillight out?
Pardon?
The probable cause for the stop is a taillight out?
That's right.
Brake light not working? A non-arrestable offense I was arrested for, and then they didn't Mirandize and furthered their investigation and threatened me to get my compliance. So, I'll go on to point 2 since that's already been established.
Point 2.
I have not appeared generally to argue the merits, but to find out what the authority of the court has over my life, liberty, and or property. I am not appearing before the court generally, but rather under protest and duress, under threat of arrest if I did not do so, and to seek evidence of jurisdiction over me. I am simply asking for the evidence that the court relies upon to prove the constitutional laws apply to me, because of my physical location of which has not been proved by prosecutor's response to my motion. The basics of the prosecution's answer is that the RCWs apply because the RCWs say they apply, and this is a circular logic, and is not evidence of jurisdiction over me. So absent the willingness to use violent force against me, what evidence has been submitted to the court of jurisdiction over me? What right or secured interest does the prosecutor or the state have over my life, liberty, and or property that gives way to the lawful use of violence against me in order to get my compliance? Who has lawful claim against me? And if there is one, I'd like to see the claim. And who? And point 3. When requested, the military court provides factual evidence of jurisdiction. So does this court's jurisdictional claim come from a presumption or from evidence? If it comes from evidence, then I would like to see it, because all I have seen are threats of being put into jail. And I would also like to know, is the court proceeding at common law or by admiralty maritime jurisdiction? And point 4. I, for the record, did not intentionally commit any crimes as alleged in this case. I was simply exercising my right to travel freely and unencumbered pursuant to Shapiro versus Thompson, and that right is so basic it need not be mentioned. The state of Washington has arbitrarily and erroneously converted that right into a privilege and issued a license and a fee for it. Murdoch versus Pennsylvania, sorry, there's a typo with an N on Pennsylvanian, strike that N please, says no state may convert a secured liberty into a privilege and issue a license and a fee for it, and if they do, Shuttlesworth versus Birmingham, Alabama says I can ignore the license and a fee and engage in the right with impunity. And that means you can't punish me. And since I have relied on previous decisions of the Supreme Court and on constitutional defenses, I have a perfect defense for willfulness. I am immune to the prosecution. Therefore, the prosecution counsel does not have a cause of action for which relief can be granted. And I motion to dismiss with prejudice for failure to state a claim for which relief can be granted. Submitted this 31st day of May by me under duress, participating with this court. And I give another proposed order on the back of that document.
Any further?
I motion the court to dismiss with prejudice.
All right, your motion is submitted. I'll hear the response from the state.
Thank you, Your Honor.
Have a seat.
Well, to start off with, sounds like rather than challenging any real legal issues under Washington state law, Mr. M is simply demanding the court provide evidence to him why it's subject to jurisdiction, which is not a challenge to jurisdiction, as I explained in my brief. The state does have jurisdiction over any person within the state under the criminal laws, and empowers the prosecutor and deputy prosecutors by statute and by case law to enforce those. Any person in the state is subject to them. Now there's a huge slew of issues here, so I'm trying to hit the main points of Mr. M's arguments, but he's saying there's no evidence that he is within the state. I don't understand how that's possible. It says clearly in the report he was in North Washington. As to the being within the plaintiff, as I said, the plaintiff is the state through the prosecutor as authorized by the Constitution and by the statutes. Furthermore, clearly there does not need to be a victim as envisioned by Mr. M, because if that were a correct interpretation, there could be no law that was enforceable which did not have a victim. For example, you could be driving DUI and not hurt anyone and not be found guilty of DUI. It's obviously an absurd conclusion. There's some issue of we're calling standing. There's confusion with the civil law here, but as I stated, the state does have standing to bring these charges. This is an adversarial cause of action between the state and Mr. M. And if the court has any questions, I'm happy to answer them.
Any response?
I object to being in the plaintiff, yes, actually. I object to his saying that I could possibly be in the plaintiff. Like for clarification purposes, can I ask where we're currently located? Like right now? Are we considered to be in the state of Washington?
Remember what I said, I'm not here to answer your questions.
You can't answer my questions at all.
Oh, I'm not going to answer your questions. I'm going to let you present your motion, present your legal authority supporting your motion, make an oral argument supporting your motion.
Okay.
I'm going to let the state respond, which I've done.
All right.
I'm giving you the opportunity to respond to the argument made by the prosecutor. And that's your opportunity to do this right now. It's not an opportunity for you to
Gotcha.
interrogate the court. So do you have anything further?
Yes. The allegations are that I'm located in the state of Washington. The state of Washington was created in 1889, I believe in November. It's a body politic. It's not a physical location. And allegedly, the laws apply within the state. I do not believe that I can possibly be in the body politic unless I am like a politician or something and being paid currently, or an employee of the government, et cetera, at all.
What do you consider yourself to be?
As far as I've been raised, I've been taught that I'm an American, and we have constitutionally protected rights, and anyways, so
You consider yourself to be a citizen?
that one's a tough subject because there's two types of citizens. There are those of the state and those of the United States. And allegedly, I cannot prove for a fact or even quite understand the separate ramifications of it, but one is actually created by statute and by law, and the other just is by natural de jure, allegedly protected by the organic constitution, where government is designed to serve and protect those people, not ride over them, regulate, legislate, taxate, or tax them. They're rather there to protect their interests. Whereas the other is an eins legis, a creation of statute or law, and is under direct is a direct subject of the United States because it's a creation of the government. And so that would fall under subject jurisdiction. It would be subject matter jurisdiction to the statutory codes. Whereas I don't believe that a man is subject to the statutory codes, but rather the laws of God. No victim, no crime. It's not like I go around intentionally hurting people. And I was minding my own business, traveling in my private automobile as a matter of right. And that's even backed up by the statutes. In my, let's see, what is that document? Let's see. Yes. Let's go open as a matter of right. Notice to court, memorandum of laws, judicial cognizance document that I submitted should be section 13, or point 13, 5th page in. Public highways of Washington State are open as a matter of right, not privilege, to public vehicular travel. In response to inquiries concerning the statutory claim, the State of Washington Statute Law Committee has directed that very particular sessions laws constitute those upon which RCW 4604-320 definition of the term motor vehicle rests, under which it is governed, and all are identical in the language regarding the scope of said term. Motor vehicles shall include vehicles and machines propelled by any power other than muscular, used upon the public highway for the transportation of freight, produce, or any commodity except traction, etc., etc. Public highway.
Is this your briefing and your research?
Yes, I've been reading since 2004.
Are you arguing that the statute you're citing under section 13 of your brief is unconstitutional?
No, I'm differentiating between travel and commercial use.
And what were you doing?
That's what's in these laws. I'm not involved in commerce. Never have been. Except for maybe when I'm working. But even then, that's subject to interpretation. But it says in the statutes that the public highways are open as a matter of right to public vehicular travel. It doesn't say open as a matter of privilege that may be given and taken away at any whim of a government official. That is a privilege. The privilege is to make money on the roads, to use the roads for private gain. Otherwise, the roads were given to us or built by us so that we could travel back and forth, go to the grocery store, go back home, go to the friend's house, go to another state to visit family members. It's not meant to be policed in the manner that it is, except for those using it for commercial purposes. City street, every highway. Let's see, RCW, where was that? RCW 47.04. Is it 47? Where did I put that? It looks like I might have omitted RCW 47. RCW 47.04.010.
What are you trying to do now?
I'm searching on the internet.
You're what?
Looking on the internet at the definition under RCW.
Everything you've argued is contained in your briefing, is that correct?
It should be. Well, yeah.
Do you have any new points to make? Because I'm gonna.
Subsection 11 says, RCW 47.04.010 subsection 11 defines highway as every way, lane, road, street, boulevard, and every way or place in the state of Washington open as a matter of right to public vehicular travel both inside and outside the limits of incorporated cities and towns. And it's my understanding that rights cannot be regulated, taxed, or limited unless it is, unless somebody's going to actually cause damage to somebody else, especially if it's purposeful, and that's what criminal intent falls under, doing something on purpose to hurt someone. So, yeah.
Is your position that the roadways under the statute you just cited are open as a matter of right, and an individual can, therefore has an unbridled right to travel on that roadway? Do not have to have a license, do not have to have insurance,
Yep.
do not have to drive lawfully, do not have to drive sober.
Well, they have to be safe in their conduct.
Right side of the road, do not have to drive at a certain speed so as to not harm other people on the road.
Mm-hmm.
None of those regulations apply because it's an unbridled right to use the road. Is that your position?
Not wholly necessarily, no, but I think as long as somebody conducts themselves in a safe manner, they should be allowed to continue on the way that we always have been.
If you're driving a vehicle that isn't equipped properly, or the lights don't work, or doesn't have a license plate, or brake lights are faulty,
Mm-hmm.
Is that safe?
Did it cause anyone direct damage?
I just want to make sure I'm understanding your argument, that you have an unbridled right to use the roadway in any way you see fit.
Yep, that's my understanding, as long as you are not out hurting people.
Thank you. All right, you can have a seat. The court has considered the plaintiff's motion to dismiss. As indicated earlier in the record, I've read the notice. The court memorandum of laws, judicial cognizance. I believe I've given Mr. M every opportunity to fully express his views supporting his motion to dismiss, letting him cite statutes from the revised Code of Washington, citing case law from other jurisdictions, interspersing portions of civil law into the criminal motion to dismiss context. The court has also considered the response to the state's response to the motion to dismiss, which was filed today, a copy provided to the court and to the prosecutor. The court has read and reviewed the state's response to defendant's motion to dismiss. And at this point, had heard the argument from Mr. Foster on behalf of the state. And at this point, Mr. M, your motion to dismiss is denied. But this court does have appropriate jurisdiction to hear the matter. The court has previously determined there was probable cause for the underlying criminal charge based on a citation that was found to be a legally justifiable basis for making contact with you on the date in question, which I don't have, unless it was 3/23/2018, it looks like in the court file. And the court is not persuaded that any of these statutes that you have argued or any of the statutes that are in play in this particular case are unconstitutional or aren't valid statutes and true recitation of what the law states and requires of an individual driving on the roadways within the state of Washington. So with that, the motion to dismiss is denied. And we're on track for a trial that we're going.
Yes, Your Honor, we're currently set for trial on June 8th. This is also a combined readiness hearing. The state's ready to proceed to trial.
All right, you ready to proceed to trial, Graham?
I object to my motion being denied as an appealable issue.
So
The state has not proven their burden.
You ready to proceed to trial?
Not really, apparently. I don't even.
Schedule as is, and Mr. Graham, you are continuing to represent yourself pro se unless the court provides otherwise.
I don't consent to the
So
jurisdiction
the
of
next
this
court
court.
hearing is when, Madam Clerk?
This is the final before the trial, Your Honor.
And
I have one more motion to dismiss to submit to the court.
I object, Your Honor. It should have been filed previously.
you need to speak up. You have one more way.
I have another motion to dismiss to file into the court
When?
right now.
Well, right now is not the time you're gonna file a motion to dismiss. And there's court rules, there's court procedures as to when you file a motion, time requirements for filing a motion. You can find those under the criminal rules for courts of limited jurisdiction.
Okay, so will I be able to find when the alleged plaintiff should have answered my motion in there? Because it took them like 2 months or more to answer my motion, and they waited till the day before pre-trial to answer my motion. Filed it May 14th. No, not May 14th.
Discovery been completed?
Discovery's been completed, Your Honor. Just for the record, my review shows that we haven't made any, I don't know if there's even an objection, but we haven't violated any time issues with the motion. As I said, the state's
So
ready.
have you advised the state on any witnesses you plan on calling?
March 28th.
And you proceeding with what an officer, I assume?
Yes, Your Honor. I have a witness list. I believe the witness list has been sent out to Mr. M. That includes Deputy Dunlap and then Hector Rodriguez or designee.
All right, so on trial days, here at what time, 8:30? 8:45, Mr. M will be present in court on June 8th at 8:45. Step up here and sign the document the Madam Clerk has for you to sign.
And just for the record, Your Honor, is the court calling the trial ready? Yes, thank you.
Mr. M, if you'll stand up here and sign the document, please. So unless there's a resolution for June 8th, 8:45 to be present in court, failure to appear results in a warrant.
Thank you, Your Honor.
Thank you.
I knew this would be a kangaroo court. Fucking joke. Fucking bitches. Hey. I'd like to file this motion. Hang on. Just so it's on the record.
Okay. I know you're very keen on talking for a minute. Oh, they did. Yes. I love that. I get an email saying, we can come in right now, like,
Of course.
geez, right now? Like right now, right now?
So I labeled each of them. So you know which one's which. This one's for the court. That way.
Works.
Yeah, whatever works, right?
Who are the lawyers? Is that codicil you just did? Oh, okay, so, they were hoping to sign through there or something? Oh, okay. There you go.
Railroaded.